Chris Davis, who literally wrote the book on dog bites, says this.
There's a human being that's been significantly harmed. To debate, okay, was it the dog that did it or was it the owner? My response is, who cares? Let's not put the rights of dogs over human beings. It's outrageous that the city would actually simply ship the dog to another jurisdiction and not take efforts to euthanize or destroy an animal that the city has already determined to be dangerous to the public.
Donna's lawyer says the dog's owner is liable for the attack.
If this had happened when there was nobody around, I mean, we might very well be talking about a fatality here.
You know, over the last 80 to 100 years, there's a significant body of law that deals with these types of cases. And the courts over the years have basically held that, you know, when a dog owner has reason to know that his or her dog is dangerous or likely to bite, doesn't have to have bitten anybody in the past, but to engage in some behavior where it could lead to a bite, then that owner actually has a duty to kill the animal or confine it so it's impossible for that dog to injure any person.
So this would apply even if he hasn't bitten anybody yet?
As long as you can prove that the owner had some knowledge of a trait or propensity of the dog.
Can that go by breed? Because I'm thinking of pit bulls now. Can you
we're talking strictly about behavior.
Actual conduct, okay.
Okay, so regardless of breed. So if the dog acts, for instance, in a menacing way, or is aggressive by barking or, you know, assuming a stance like the dog is going to attack, that would put a reasonable dog owner on notice that the dog is probably dangerous to humans and would likely bite.
All right.
So as that body of law began to develop over the last 80 to 100 years, it became very difficult for dog bite victims to actually prove what the owner knew about his or her animal.
Mm-hmm.
So about 30 years ago, our legislature then enacted a statute, a specific statute called the Dog Bite Liability Statute, which says that basically it doesn't matter what the dog has done in the past. If your dog bites somebody while that dog is either on your property or public property, the owner is strictly liable for the harm.
Chris Davis is her attorney. He describes the attack that happened in July when Cunningham was walking here along Southwest 143rd Street, and the dog got out of this yard.
If you can imagine a dog comes out of nowhere and jumps up on you and attacks you and essentially rips off and chews up your lower lip.
So if you're bitten by a dog, how do you know you actually have a legal claim?
I think most people know that when a dog bites or injures another human being, there is a claim, and usually there is. However, if the dog causes any other type of injury or damage, for instance, if the dog chases a young boy and that boy, you know, runs out into the street and is hit by a car, a claim may exist in that situation. Or if a dog jumps on a young child and causes that child to fall down the stairs, generally a claim will exist in that situation. It really comes down to whether the owner had the dog or owned the dog, legally owned the dog, and where the incident actually took place, whether it was on private or public property.
Strict liability, say, doesn't matter if the dog owners were being responsible. They are strictly liable for anything their dogs do, period.
That's correct. There's, as long as the bite or the harm by the dog occurs on public property, and as long as the victim did not provoke the dogs in any way, which is a complete defense under the law, then the dog owner is completely liable for damages that were inflicted upon the victim.
There are many who believe that certain breeds are discriminated against. Well, you can only discriminate legally against people, not dogs.